Welcome to our webinar presentation by Gallagher & Kennedy and sponsored by R.C. Thornton & Associates. Today we are discussing paid sick time FMLA for coronavirus absences. If you would like to sponsor one of these webinars at no cost for your colleagues or with your trade association, please call our office for details or send an email to info@rcthornton.com. It is free and we would love to work with you on your specific topic of interest for your business. If you have any questions throughout the seminar, please email them to chuck@rcthornton.com. It is my pleasure to introduce you to our sponsor, Chuck Thornton of R.C. Thornton & Associates, CPAs. Chuck works extensively in the tax area. He is an author, lecturer, and frequent guest webinar presenter. The firm's mission is to help clients achieve financial success, and that means saving taxes. He works with numerous consultants like our speaker. By doing so, he brings in specialty and expertise in certain areas needed for effective tax planning. Chuck's background includes being a CPA, personal financial specialist, charter life underwriter, and certified financial planner. He is a graduate of New York University with a master's in taxation. Please don't hold this against him, but he did work for the IRS a long time ago. He is also owner of R.C. Thornton Financial Solutions, LLC, another CPA entity specializing in investment planning. Today, he is the moderator of our presentation. So Chuck, would you please introduce our speaker?
Yes, thank you, Kit. I appreciate that introduction for you. This is kind of a special presentation. This is a special time that we have going on with our economy and different phases of economic stimulus laws that have come out. One that you probably heard about, which was phase 2 of the economic stimulus, has to do with sick leave, both for yourself and also for dependents or children that you might have. This is really heavily an area of what would be in the human relations departments as to how these policies are going to work. First person I thought of asking to talk with us was Don Johnson of Gallagher & Kennedy. I've known Don for forever, it seems. He has helped many of our clients, and quite frankly, he helps me too whenever I have any employment type related questions, and a lot of our clients have also used him. He's excellent. Thoughtful, knowledgeable, and he's also been named among the best lawyers in America, as 2/3 of his fellow shareholders are of his company. I didn't really realize that at the time. He's also worked for a law firm in Minneapolis. I didn't realize you were such a cold area there, Don, and he's also served as a clerk for Chief Appeals Fourth Circuit. So I will talk a little bit about the tax issues that come up, but I think this is primarily more of a Leave Act, and everyone who is in business needs to know about this. So Don, I'm going to turn it over to you.
Thanks very much, Chuck. I really appreciate it. Chuck's right. We've known each other for a long time. Of course, as Chuck was introducing me, I felt, you really don't have to know a lawyer very long to feel like it's been an awful long time. So I appreciate the sentiment anyway, Chuck. Thanks very much. Let's move right out and talk about the Families First Coronavirus Response Act. As Chuck mentioned, this is the second significant piece of legislation that Congress has enacted to deal with the coronavirus epidemic. It was signed into law on March 18th, and it becomes effective or takes effect April 2nd, 15 days after the law was passed. The first big eligibility criterion is that it applies to all employers with fewer than 500 employees. Some of the philosophy in Congress was that the kinds of leave, paid leave, and so on provisions that we're talking about here are generally pretty common among employers with more than 500 people on the payroll. The idea that those companies are already providing paid sick leave that might be useful in this crisis situation. And so the law is designed, is oriented toward employers with fewer than 500 employees. So that's the audience we're talking about. If your business has fewer than 500 personnel, you are covered by this law. The law sets up two basic components of paid leave. We'll talk about them in order. The first is the Emergency Paid Sick Leave Act. This portion of the law basically provides just a straight 2 weeks, 80 hours of paid sick time for certain kinds of absences from work that arise from COVID-19 or coronavirus. It is 80 hours or 2 weeks. It is prorated for part-time employees. The way the law is set up, we would look back over a representative period during which the part-time employee worked and gauge his or her average hours worked during a normal 2-week period. And once we do that analysis, then we know that's how much paid sick time that part-time worker has. So just remember prorated for part-timers. And another big thing to remember, we've gotten a lot of calls about this issue, and so I want to emphasize, we're only talking about paid sick leave if the worker is unable to work or telework. Many of us have been working on implementing or refining existing policies for remote work or telework over the last, since this crisis began. And so this law is designed to account for that dynamic. This law basically means that if an employee is able to telework, then the employee is not really eligible for paid sick time under this law because that is not an absence. The employee is simply working remotely and therefore not absent from work. Of course, the entire issue of remote work raises a host of other management concerns that are sort of beyond the scope of this particular webinar. But if you have concerns yourself about how to establish or manage a remote work protocol at your location, that's certainly something that you can ask about separately if you'd like. But again, just a critical point to remember is if an employee is able to work remotely and you have work for him or her that can be done efficiently by remote, then that employee is not absent and therefore not covered by this law. So keep that in mind. Let's talk about the basic provision, the basic compensation or sick pay that the employee who is absent because of this crisis will be able to receive. Under the emergency paid sick leave provisions of this bill, the employee will be eligible for sick pay calculated on the basis of his or her existing regular rate of pay, but subject to a cap of $511 per day and $5,110 in the aggregate for that employer, for that employee. Again, even I can do that math. We're talking about a 2-week, 80 hours of paid sick time. So at $511 a day under the cap, that's just over $5,000 total that the employer would be obligated to pay for that employee. Now, this benefit applies if the employee is absent due to one of the following 3 reasons. If the employee, him or herself, is subject to a quarantine or isolation order, he or she has actually been ordered to be quarantined or isolated. If the employee has been advised by his or her healthcare to self-quarantine due to the possibility that he or she may have been exposed to a coronavirus, or if the employee is experiencing symptoms, actual symptoms of coronavirus, and is seeking a diagnosis to determine whether he or she actually is infected. Any of these 3 reasons, these are the reasons that qualify for sick pay under this first component of the Emergency Paid Sick Leave Act.
Don, if I can jump in with a question. By the way, these are not live questions. We're just simply recording this right now, but these are questions I've been pondering as we go along. Several questions on this slide. It says employees subject to government quarantine. If Ducey, governor, came and said everyone has to stay at home except for certain businesses, is that considered to be a government quarantine?
That would most likely not be a government quarantine. In other words, in many states, we know governors have issued executive orders basically telling people to stay home or shelter in place, if you will. Those kinds of orders telling people to stay off the streets are not the kinds of quarantine or isolation orders that this law contemplates. What we are talking about is if some government official, most likely a public health official, designates any individual or group of individuals specifically to isolate or quarantine in the way contemplated by the law. Not just not come to work, but close up in a individual space, such as a bedroom, and stay there. That's the kind of quarantine or isolation order that we're talking about under this statute.
Okay, now, I could see where some of this could be abused by someone. I'm looking at number 3, someone experiencing symptoms of the CV-19 and then seek diagnosis. And so they declare that to you, and then maybe it takes them 4 days to get the diagnosis. Therefore, it would appear that they get paid $511 per day. But my real question is this. How far, if any, can we go as an employer into saying, well, what's your situation? I need to see a doctor's report, prove what you're saying. Any tips for us on how to handle those situations?
You bet. I guess the first point to make is, as no surprise when we're talking about a law that is cobbled together in such a hasty fashion as this one, the law itself does not tell us what kind of documentation employers may or should require. However, the law does delegate the Secretary of Labor Department to draft and some regulations and to implement some regulations that hopefully will flesh out some of those finer details. We are, at this moment, when we're recording this webinar, we're still waiting to hear from Department of Labor for some regulatory guidance, and we hope there will be some guidance on this particular issue. But the other point I'll mention is, I think, remember how this typically, how this would be playing out if it were to arise. You'd have an employee in the workplace who claims to be experiencing symptoms of COVID-19. Well, I think in this day and age, a lot of us are going to be happy to let that person be gone. You're going to have a lot of coworkers in the office who would be very anxious to have that person continue to be coming in every day, sitting over in the next cubicle, coughing and feverish. And so I think there's going to be a lot of us who would happily say, go ahead and take this time off. If you say you're experiencing symptoms, go ahead and leave. Stay out of the workplace. There will be a sick pay provision for you. There's another reason why, and I guess what I mean by that is there's going to be some practical reasons why I think a lot of employers are not going to be anxious to require a lot of documentation. So I do think I would be recommending to my clients that that they encourage, or I would encourage my clients to go ahead and ask for some documentation or backup, even retroactively. Once the employee feels, once the employee's situation is resolved, they come back, maybe just ask for some confirmation from healthcare. I think that would be fine and a perfectly good judgment. But there's another reason why I think a lot of employers, if we think this through, need not be overly concerned about people really manipulating this or working this system. And that deals with the tax credit issue, which we'll talk about a little later. As many of you know from just reading the press about this law, the dollars that employers pay out as sick pay will be a credit against the employer's payroll tax at the end of that quarter. And so that's a nice comeback for the employer. So those are a couple of thoughts about those points on this first component of, or these first 3 situations when employees are eligible for emergency paid sick leave. The law then lays out 3 additional circumstances when employees also are entitled to paid sick leave, but it's a different benefit. It's a less financially beneficial benefit. Under these provisions of the law, the employee's sick pay is calculated at only 2/3 of his or her regular rate of pay, and then also capped, but at a much lower cap. As we see, the cap for this component of paid sick leave is $200 per day and $2,000 total for that employee. And those caps, the 2/3 of regular rate subject to a $200 per day cap, apply to absence for any of the following reasons. We basically see an employee who is caring for someone who is subject to a quarantine or isolation order, or who has been advised by healthcare to self-quarantine. So think about a spouse, a partner, some other, any other family member who, think about such a person who's subject to one of these orders from the prior slide. In other words, these components of sick pay apply to when the employee has these issues. These components of sick pay apply when somebody at home has these kinds of issues. That's the first element here. The second situation or type of absence that is eligible for emergency paid sick leave is if the employee is caring for his or her child whose school or daycare has been closed due to COVID-19, or whose childcare provider cannot perform due to COVID-19. Many of us are living that reality right now. Schools in many locations, my own school districts, well, all schools in Arizona are functionally closed for the time being. And so that means there's a lot of young people who have to spend the day at home. And so if your employee is home caring for his or her child in that situation, that's an absence that counts under this Emergency Paid Sick Leave Act. The employee is only entitled to 2/3 of their regular rate, and it is capped at $200 per day, but that's an absence that qualifies here. Congress also included a third scenario, basically just a placeholder, if you will, a catch-all, in situations when an employee is experiencing substantially similar conditions to be defined and described by regulations issued by the Department of Labor. We're still awaiting those regulations at this time, so we'll see what the Department of Labor might lay out in terms of other kinds of conditions that meet the same sort of emergency nature and level of crisis as elsewhere in the statute. But these are these situations when an employee will be able to receive sick pay at the 2/3 rate, with these statutory caps also in place.
Don, a question. First of all, we probably should have mentioned this at the beginning of the seminar. This is information that's available as of March 26th, and this is some of our interpretations. Department of Labor still has yet to come out and give guidelines on this. So if you're listening to this, you might want to make sure you're updated if you have an event that happens after the date of these slides, simply because maybe something might have changed. My particular question, and you and I did talk about this, is that let's say you're staying home and you're qualifying under the Emergency Paid Sick Leave Act, which is a 10-day, 2-week type thing, and lo and behold, on day 6, you get sick yourself. Is this 10 days collectively for both of these, or can each one run 10 days on its own?
My interpretation is that the law is designed to create a 2-week cumulative or collective total of paid absence. And if one or more of those 10 days is an absence that occurs under one of these conditions, and then the employee has a second absence attributable to a different one of these conditions, the employee does not get 2 10-day periods. The employee gets one collective 10-day period of absence that's covered by this law. The rate of pay that the employee is eligible for might vary depending upon whether the employee's absence is caused by one of the first 3 situations or caused by one of the second 3 situations, which we see on the screen now. But I do feel strongly that the way the statute is crafted, it really grants a collective or combined total of 10 days of sick pay. A couple of other issues to consider under the Emergency Paid Sick Leave Act. As hopefully all of you know, Arizona, since July of 17, has mandated paid sick time for all employers in the state. As many of you will recall, the law dictates that all employees accrue 1 hour of paid sick time for every 30 hours worked, subject to a cap of 24 hours of paid sick time available that they can accrue or use in any 12-month period. The question comes up as to what's the impact of this new federal law on Arizona's existing paid sick time provision. Most of us here have had at least, well, we've all had a couple of years to live with this law, and we're starting to get used to the paid sick time component. How does that play out with the new federal law? Well, the new law, the federal law, does state that it cannot be construed to diminish any rights or benefits that are available to any individual under any other federal law, any state law, or any existing employer policy. And my interpretation is that this really means that an employee who qualifies for this emergency paid sick leave under the federal law retains his or her accrued paid sick time under Arizona's Prop 206. In other words, we can't run those two benefits at the same time and basically count the federal paid time as drawing down on the employee's Arizona Prop 206 paid time. Prop 206 time, in my view, is going to remain available for use by those employees who have used the federal Paid Sick Leave Act. Let's shift gears to the second main component of this law, and that is an expansion, a temporary expansion of FMLA, or Family Medical Leave Act. As most of us are familiar with, the Federal Family Medical Leave Act has been in effect since 1993, and it provides that employees are eligible for time off from work, job protected time off, under certain circumstances, usually a serious health condition for the employee or a spouse or child, and for the birth or adoption of a baby. Those kinds of things are among the types of absences that can be covered by federal FMLA. Many of us have years of experience dealing with FMLA issues. So the new federal law basically creates a new category of time off or absence that qualifies for treatment as FMLA. And that category is here on the screen. An employee who is unable to work or telework, again, that important distinction, due to his or her need to care for a minor child whose school or daycare has been closed due to a public health emergency, or whose healthcare provider or childcare provider is unavailable. So now again, here in Arizona, all of our schools have been closed, and so an employee who is unable to work because he or she needs to care for a minor child whose school has been closed, that person is going to qualify for this new FMLA benefit. Now, it's probably also significant to point out what this new FMLA benefit doesn't apply to. It doesn't apply to absences in which the employee, him or herself, might be sick. It doesn't apply to absences in which the employee's spouse might be sick. This new FMLA benefit only applies when we're talking about a minor child whose school or daycare facility is out of operation due to a declared public health emergency, such as we're experiencing now. The law also contains a couple of big distinctions from the existing FMLA in terms of eligibility. For example, under the existing FMLA, as most of us know, the FMLA only applies to individuals who have been with the company for at least 12 months. The employee also must have worked a certain amount of time in the preceding 12 months, 1,250 hours. But the gist of it is, again, for the last 30 years or so, employees are only eligible for FMLA if they've been with you for at least a year. Well, this new law applies this emergency FMLA to a substantially broader universe of employees. Under the new law, individuals who've been with you for only 30 calendar days are covered by this benefit. They're not covered by or eligible for other types of FMLA, such as birth or adoption of a baby, that kind of thing. But anybody who's been with you for at least 30 days is now eligible for this particular FMLA expansion. So it's going to be important to keep that distinction in mind when implementing and enforcing this new FMLA expansion benefit. Let's talk about what that benefit, the employers to whom that benefit also apply. Again, under current law, under the existing FMLA, that law only applies to companies with 50 or more employees. And that's a big dividing line for, in Congress' mind, for small business. And so the existing FMLA only applies to companies with 50 or more. Under the new law, this emergency provision applies to all employers with fewer than 500 employees. So any company with 499 workers or less is going to be subject to this this new emergency FMLA provision. So that's a very important distinction to make. A critical distinction for those of you who have fewer than 50 employees. If you've had fewer than 50 employees for any significant period of time, you may have never heard of the FMLA. It hasn't applied to you ever before, so you may not have any experience dealing with it. So you're going to have to get familiar with it pretty quickly. So beware of that. If you've got fewer than 50 employees and have never been covered by FMLA, now you are, at least for the purposes of this emergency provision. Now, one little life raft that Congress cast out on this bill, the statute authorizes the Department of Labor to exempt businesses with fewer than 50 employees from the provisions of this emergency FMLA, provided that this new FMLA provision would jeopardize the viability of the business as a going concern. And so one of the frustrating things for us is that the law does not give the Department of Labor any particular parameters or standards or criteria by which to judge or conclude whether or not an employer should qualify for this kind of hardship exemption. But the exemption will be there, and so we know that the Department of Labor will come up with some lifeline or some criteria that'll tell us who can qualify for this exemption. So be alert for that. Let's talk about what the benefit is that's available to employees who are covered by this new law, of employees of employers who are covered by this new law. The first basic benefit under the FMLA Expansion Act is that the employee is entitled to take time off for one of the absences we discussed. And under this new law, that first 10 days is not required to be paid. The employer may pay if it wants, but the employer is not obligated to pay for that emergency FMLA time during the first 2 weeks. Now, these two laws obviously fit together. Somebody who is taking emergency FMLA, as you'll remember from earlier in the presentation, that person would qualify for emergency paid sick leave for 2 weeks. And so even though the FMLA says the first 2 weeks or 10 days are not going to be paid, keep in mind that first 10 days would be paid under the other provision of the law. So it can be important to keep that in mind. An emergency FMLA that extends beyond 10 days is going to be paid. It's going to be paid based on the same rates that we discussed earlier for one component of emergency paid sick leave. It's going to be paid at not less than 2/3 of the employee's regular rate, but subject to a couple of statutory caps. There's a daily cap of $200 per day, and because FMLA, as most of us know, applies only for 12 weeks anyway, the employer's obligation is capped at $10,000 in the aggregate for that employee. So if you step back and think about it in a larger perspective, these two laws basically fit together to give a worker whose child is at home due to school closure because of coronavirus, that person's going to be eligible for 12 weeks of paid time off. It's going to be paid at these lower rates, 2/3 of his or her current rate, and subject to a $200 per day cap. But that's the big picture benefit, is paid time off for school closures, basically, for 12 weeks. Now, a little bit of the good news, and there is some. As I mentioned earlier, Congress did dictate that any amounts that are paid out as paid sick leave or emergency FMLA leave, those amounts are going to be credited against the employer's quarterly payroll taxes. An employer who might pay some individual worker more than the statutory obligation, that an employer could do that if they wanted to, but the employer will only be able to take a credit for the amounts set forth in those statutory caps we discussed earlier. I guess for a quick example, if any particular employee's statutory cap was going to be $200 per day, if the employer wanted to go further and pay a little more than that, the employer certainly could. There's no law against that, but the employer would only be able to take a tax credit for the $200 per day that the employer is paying to that worker. And the good news continues is that it is a refundable tax credit. So at the end of the day, if the credit works out that we, the taxpayers of America, owe you money, well, you're going to get a check. Chuck, you're obviously the tax man here. Anytime I see tax on the screen, you know, I call Chuck. So Chuck, let's get some of your thoughts about this tax credit component of the new statute.
Sure. You actually did a very good job, Don. If you ever want to become an accountant, let me know. But anyway, I do have a few comments, but remember again, this is as of March 26th, and who knows what interpretations are going to come out on this. The statute basically says you get a credit against the employer's quarterly payroll taxes, which would be defined as 6.2% of the employer's portion of the FICA tax. And most people believe that that's how it works. And so what would happen is you might decrease your deposit by the 6.2% portion of it. And then when you get down to the filing the quarterly return, then you show the total amount that you paid, and you would show the credit, which could be either an overpayment or actually getting a refund, just like if you overpaid your payroll taxes for a particular period of time. Now, one might wonder, why are they going to make you wait when the idea here is for you to get your money as quickly as possible? It'd be kind of counterproductive to say, pay this money out, we'll give you a little bit of a credit on your deposits, and then you have to wait to get the refund at the end of the quarter. The IRS website says something different from what I've just said. They say that payroll taxes include not only the 6.2% that the employer pays, but also includes the employees and withholdings. And that would be more generous to employers paying this. It even goes on to give examples of that, where indeed they do show that you're going to get a credit against the full amount. Now, that would be nice because you can start getting the benefit of this quicker than only against the employer's portion of 6.2%. I was visiting with a group of people who were very interested in this, and I brought that up. I said it's on the website, and I've been looking at the website almost every day to see if they take it down. And they don't. They haven't taken it down. It's there right now. If you went and looked it up, you'd find that example on there showing the same thing. Intuitively, it makes sense. You're going to get the money back anyhow, so why not give it to you sooner? The real question you run into is do you start taking advantage of this with the deposits, and then the IRS changes their mind and says, oops, you're only going to get the credit for the 6.2, and then do you start setting yourself up for penalties? Now, I have to admit, that would be rather heartless on the part of the IRS to do that, but when it comes matter of the heart, I would not bet on the IRS being harmful all the time. So all I can say is, as of right now, there's a conflict between what the statute says and what's on the IRS website. So if you find yourself in this situation where you're now starting to want to take the credit as you go, it might be time to give a call and find out what is the update on that. Your payroll provider, like Paychex or ADP, are going to have to wrestle with this question themselves. And I've tried to find input from both of them as to what they're doing and no one has any decisions on this yet. There's also another point to bring up, and this is an iffy thing, but there is a phase 3 of this tax law that if you've been paying attention to it, the Republicans and Democrats are arguing, the Senate agreed, the House supposed to vote on it Friday and hopefully it'll be signed on Monday, but they've been saying this for a while. And the question becomes, is there's a series of employee protection loans that you can get, and they do require that you do not take the credit on this amount. So even as you might think you're eligible for this, you may find out that you might be eligible for other benefits basically sooner than what you thought, depending if this law passes. So there's another decision lurking around that didn't exist when this law was passed that might cause you to say, I'm not going to take the credit. And then finally, this whole law revolves around 500 employees or less. But there is an exception. Now I see it in the new tax act coming out that hasn't passed yet that says the 500 is applied at each location level. Let's say you're a restaurant, let's say you're a franchise, and there's some wording in there about franchises. Let's say that you have 50 or 60 employees at each location, but you have 10 different locations and maybe you do have 600 employees, and it would seem like this provision might not apply. The theory that Don and I are talking about is if that is correct, perhaps this backdoors companies with more than 600, 500 employees into being able to get a credit. This is an unknown issue right now. And I had almost automatically said employers over 500 are not going to get the credit until I started looking at these new provisions coming out. So it's another open issue that if you have 500 more employees, but at each location you have less, maybe there'll be something there, something to be discussed as you move along and find yourself making these payments. That's it for me, Don.
Well, Chuck, I appreciate the input. You've thoroughly convinced me that, boy, am I in the right job, and I'll leave the public accounting to those of you who are certified. Move on to a couple of other provisions of the statute. The law requires that employers post notice. Most of us, of course, are familiar with the general obligation to post things like wage and hour notices, EEO notices, those kinds of things. And so this poster would go in the same general place in the workplace where you currently post those kinds of notices. The Department of Labor does have a poster available, a sample poster which is designed to meet the requirements of the statute. And that poster is available on the Department of Labor's own website with the prosaic name www.pandemic, basically. So very cheerful to deal with the Department of Labor these days. But that website does have the required poster. So maybe put one thing on your checklist, whatever else you do by April 2nd, make sure you have this, make sure you've accessed this poster and downloaded it and put it up somewhere in your workplace. And here it is, as a matter of fact. This is what it looks like, very simple, very easy to download from the Department of Labor's website. A couple of words about enforcement of these new laws. This law does contain some strict anti-retaliation provisions. Under those provisions, it is illegal to terminate someone or otherwise discriminate in any way against someone, which typically means taking any kind of adverse action against him or her, whether it's some kind of discipline or pay cut or other kind of adverse action. It's illegal to do those kinds of things against anyone who has used some right under these statutes, that is, taken some paid sick leave or requested some paid sick leave, or who has taken an emergency FMLA, or who has asked to take emergency FMLA. The anti-retaliation clauses also apply to any employee who has complained about something like this, or who has participated in a review or investigation into a complaint under these statutes. Those kinds of individuals have a certain level of protection against any adverse action. So beware about subjecting anyone to any adverse action who has recently taken some leave under this statute or has raised any issue under this statute, because that would be viewed as retaliation prohibited by this new law. Under the statute, failure to provide emergency sick pay is treated basically as a violation of the Federal Fair Labor Standards Act, minimum wage and overtime. And under those statutes, someone who is wrongfully deprived of his or her emergency sick pay, they would be entitled to the pay that they should have received. And then under the law, they're also eligible for liquidated damages. And if they win their case, they're going to be awarded costs and attorney's fees as well. And then the big kicker from my perspective as somebody who makes his living defending employers in lawsuits over these kinds of things, is the potential under these statutes for a kind of a class action. Under the law, it's actually called a collective action, but any sort of a lawsuit filed by a group of employees, all seeking to recover similar or identical benefits, they can combine in a collective action against the employer and basically increase their leverage in a lawsuit over this issue. I mention this because, as many of you know, we've seen a real explosion in collective action or class actions against employers under the Fair Labor Standards Act over the last few years. And they continue to be very common, and they're very troublesome for us to deal with. So there's a lot of people in town who are well versed in filing collective action suits against employers. So beware of any kinds of any questions that you may have about this new statute. Think hard and make sure you're getting it right, because if we don't, we're going to be likely hit with a collective action filed by some lawyer or another in town. A couple of other thoughts, some other places you can turn for assistance here. As I mentioned earlier, the Department of Labor has put up a pretty good website with a good number of resources for employers on these new laws. Department of Labor has published several different fact sheets dealing with different issues, sort of a Q&A publication, all available here on their website, again with the nice pandemic in the URL. Note that the Department of Labor certainly will post notice of its new regulations in the same place. When those regulations get publicized, when the Department of Labor does issue those regulations, we'll see those regulations here on this web page. And so those of you who may be interested in seeing what the Department of Labor does to try to fill in any gaps or give us additional guidance, you can check out that web page from time to time as well and find the straight word right from the Department of Labor. The other thing I will mention is we try to keep our clients and other good friends up to date with information that we feel is particularly critical. I send out advisories on these kinds of things as we feel the critical need does occur. I don't tend to paper inboxes with just needless emails just to keep my name out there. I tend to reserve them for situations where I really feel there's something that my clients and other good friends really need to know. So if you have interest in being included in those kinds of advisories, please feel free to send me an email at the email address you see here, dpj@gknet.com, and I'll make sure you get on the list for any future advisories. So I think that really concludes my own discussion about these new provisions of the federal law. Chuck, let me see if there's questions you have in your mind that I can answer for you, and hopefully we'll be able to solve some issues that some of our listeners might have at the same time.
Okay, Don, thank you. By the way, before we do that, you'll see on this slide Don Johnson's phone number, 602-530-8437. I would encourage you that if you do not already have an attorney who handles these employment type matters, that maybe you call and get a little rapport going with them, because this kind of area is going to be filled with landmines that are coming up, and you need to make sure you have someone like Don, and there's other attorneys also that are on top of this. And so he would be able to help you if you have questions on the tax aspects of it. We can help you with that too at the same time. As far as questions, Don, we typically open it up for questions at the end, but as I mentioned, this is being recorded, and you and I had decided that I would just kind of ask the questions as we went along. So I think that I've hit the questions that I think would have been of interest to people. And so I guess at this point, although I will be closing things down here in a moment, I don't have any questions, but do you have any parting thoughts on anything?
I guess the only thing I'll close with, Chuck, is we have, obviously, we're in a crisis situation here, and I encourage people to remember that under this statute, it's designed to basically give you a credit for the dollars that you're paying under these two components. So even though the statute does lay out a basic provision of up to 12 weeks of paid time off for workers in particular circumstances, it is a credit against your payroll taxes for that quarter. And so it's not as bad as you might have felt at the outset. We'll all get through it together.
Effectively, what's happening is the employers are the conduit for government payments is basically what's happening on that. It's just an issue of timing. Okay, so I'm going to close it up in a moment here, or right now, I guess. I'll turn it over to Kit. Don, first of all, thank you for leading your expertise. I know that you had to spend a lot of time just learning what this was coming up and doing some interpretations also. I want to let you know a little bit about what's coming up for people who receive these from us. I'm waiting to see if this tax law gets passed. I'm hoping on Monday it'll be passed, and I've been on top of reading the details on it for quite some time. Something I normally don't do until the law passes, because you can spend lots of time reading about things that they don't actually pass. But there's a lot of provisions coming up that I think will pass that are very important, especially for clients that have businesses and they're looking for funding from different sources. There is some built-in law for funding of economic disaster areas through the SBA. There's also other particular things which I'll be talking about. So I think you might want to stay tuned, and when we do that recording, we'll send that to you. There's also a big section on the individual side, just as one example, not being forced to make required minimum distributions is one. Another one is borrowing money from your IRAs, paying back over 3 years, not creating it as a distribution. So there's a lot of little things like that that are individual and also business, but we must wait until this thing passes so we can prune out the things that don't actually take place. Okay, Kit, with that, I'm going to turn it over to you to close things down.
Great. Thank you so much to everyone watching this webinar today. Again, thanks to John Johnson for the informative presentation and Chuck Thornton for sponsoring. I would like to mention, if anyone is interested in sponsoring one of these webinars or presenting, please call our office for details, 602-678-7067. It is free, and we would love to work with you on your topic. Thanks so much, and have a great day.